Hello, welcome to the Law Professor channel. In today's presentation, we shall be looking at how we use the trust concept to try to settle property disputes between a couple, between a husband and wife, particularly with reference to the English position and the Nigerian position. Where you have a dispute as to beneficial claim to a particular property, either during the marriage or when the marriage has broken down and parties are trying to go their separate ways. How can we use the concept of trust to settle property disputes? Bearing in mind the fact that in Nigerian law, for instance, the law adopts a strict property law position to property disputes, even between husband and wife, such that the starting point is to say that the title to a particular property, for instance, a piece of building, belongs to the person whose name is on the title deed. For instance, certificate of occupancy. That is his premise of property law. Who is the owner of this property, and that ownership is according to the strict rules of property law. So today we want to see if the trust concept can be of assistance where parties in a marriage or third parties are trying to claim a right of beneficial ownership, that is absolute ownership to a particular property, either exclusively or a case for joint ownership. So in that respect, we'd look at we look at the perspective from English law and the Nigerian position. The learning outcomes for this presentation are threefold, which would understand how trusts are useful in property claims. What do you mean by trust and how can it be utilized? They would appreciate which types of trust can be used, and they understand the limits and the challenges that each trust concept has with respect to settling property disputes between husband and wife or vis-a-vis third parties, where third parties may have a claim against either or both a husband and wife. Now, what is a trust? A trust is a creation of law which vests legal and equitable title to a property, that is the trust party, in the trustee and the beneficiary respectively. So you have a division of rights. The legal title is vested in the trustee, while the beneficial title rests in the beneficiary. The equitable title rather rests in the beneficiary. So it gives the beneficiary an equitable proprietary right in the trust property. And trust could be of various types. You can have express trust, implied trust, and resulting trust, constructive trust, and other kinds of trust. The idea is that in those trusts, one unifying factor is the fact that the legal title to a piece of property is vested in A, and the equitable title is vested in B, the beneficiary of the trust. And when it comes to spousal property rights, determining which trust vehicle, which trust concept to use is not so easy, because every one of the trusts that we're looking at has its own indicators, its own elements, which the laws have prescribed and which must be fulfilled even when you have a marital dispute. So we will try to see how this trust concept can be of assistance to settling disputes as to who is the owner of a particular piece of property between the husband and wife, or sometimes where there are third-party claims, and it is necessary to determine who is the owner of a piece of property between the husband and the wife. Now we limit this presentation to look at those trusts that can be utilized, and we'll look at the resulting trust first. When you have a resulting trust, you have a situation in which a person, it comes in various ways, but for the ones that would really be of assistance to us is in a situation where one person makes a direct contribution to the purchase of property. For instance, you want to buy Black Acre, and A pays 50 million for Black Acre. But the Black Acre, A has it conveyed in the name of B, for instance. The title deed is prepared in the name of B. In that kind of a case, the law will presume a resulting trust in favor of the financier, that is A, who paid for the money. The law will presume that B is holding that property in trust for A, who actually paid the purchase money. That is what the presumption of resulting trust does. Like I said, there are so many other ways that a resulting trust can arise, but we'll limit ourselves to those that are important for this field of law. So where that takes place, B is regarded as a trustee. A resulting trust is presumed to have arisen based on the conduct of the parties. Resulting trust, where it is applied to marital property disputes, therefore, you may have a situation where the husband buys property and puts the name of the wife. Or the example I've given, the A has paid for Black Acre, but the property, he has it conveyed in the name of B. So legally, B is the legal owner of that Black Acre, but the law says he is a trustee. So the equitable title will still reside in A. So the resulting trust in that case, because B, the property was conveyed solely in the name of B, the resulting trust is presumed against B in favor of A. B is construed, though he is the sole legal owner, to be holding the property in trust for A, who paid the purchase price. It may also be, so it may arise in favor of a sole legal owner. Or you have a situation where, in the example that I've given, A pays for Black Acre 50 million, but the Black Acre is conveyed in the name of A and B. The title deed, certificate of occupancy, is prepared in the name of A and B as owners of the property. The resulting trust would arise in favor of A regarding the 50% of the property that is held in the name of B. So it can arise where B is the sole legal owner, or where B is a joint owner with A with respect to the same property. The resulting trust, therefore, raises a rebuttable presumption. The presumption of resulting trust is rebuttable. It can be displaced by actual evidence of what the parties intended to take place. If there is evidence that, for instance, A intended that B be the owner absolutely of that property, the evidence must be brought before the court to rebut that presumption. Now, when it comes to matrimonial property, the resulting trust, the courts have held that for you to rely on that kind of a trust, you must have direct financial contributions that has been made by one spouse with respect to the property in dispute. So you have a marriage that is breaking down, and the wife says, this property, this matrimonial property, or this property in Banana Island is in the name of my husband, but I am also entitled to a beneficial interest. When we talk about beneficial interest, we're talking about an ownership rights that we are. So she says, we are joint owners of that property, even though it is conveyed in the name of my husband. The law regarding resulting trust would not recognize indirect contributions. What do we mean by this? Like she coming to court and saying, well, because I contributed to the development of the family, I took care of the needs of the family, I was doing the chores, I was doing the cooking, I was doing, therefore I should have a claim. Those kinds of arguments do not count when it comes to resulting trust. There's always been the emphasis that there must be direct financial contribution. She must be able to come to court and say, out of that 50 million that was paid on Black Acre, for instance, I paid 5 million. So my interest is commensurate with 5 million. So courts in Nigeria and English law have tended to ask that there is strict proof of direct contributions before you can have a trust. Street proof, like bringing direct evidence that you paid some money towards the acquisition or development of that property. So you have SN and SN, Gizin and Gizin, Rima and Rima. These are English cases. Adaku Amadi and Edward Husu, which have tended to emphasize the need for direct financial contribution, to the property that you want to be held in trust. If that evidence is available, then the husband will be held to be holding the property in trust for the wife. And regarding quantity of contributions. In Gizin and Rima, for instance, the claiming spouse didn't have their names on the title deeds, but they were asserting a beneficial interest, relying on the trust concept. And the House of Lords held that no rights of ownership will be established outside the evidence of clear intention that they should be joint owners of that property. Now, there's also, as we have the presumption of resulting trust, we also have a presumption of advancement in English law. Now, the presumption of resulting trust says that A, buying, for instance, property in the name of B, that B is holding the trust, the property in trust for A. Then there is the presumption of advancement, which is about gift. Advancement means a gift in law that another gives in his lifetime with respect to some real property. And this presumption of advancement is an exception to the resulting trust. What it does is that while the presumption of advancement, resulting trust says that, okay, B, in favor of whom Black Acre had been conveyed, is holding the property in trust for A, who paid the purchase price. The presumption of advancement tries to raise the argument that A intended to gift Black Acre to B in certain cases, that A intended to gift Black Acre to B. And where does this arise? The presumption of advancement arises in some special relationships. Equity will presume advancement that is gift, where there's a relationship between husband and wife, between fathers and their children, and between a man and his fiancé. These presumptions are a reflection of the historical evolution of the laws related to marriage, because husbands had a duty at common law to take care of their wives. Fathers have a moral obligation to support their children, and then a man and his fiancé. The presumption applies in favor of the wife, in favor of the child, and in favor of the fiancé, and not vice versa, respectively. That is, a wife is not presumed to gift property to her husband if she buys property in his name. But where a husband pays for a piece of property, pays for Black Acre, and writes the name, puts the name of the wife on the title deeds, the presumption of advancement arises. It's a presumption that is reportable. It arises to say that the husband intended to gift that Black Acre to the wife, to gift, so that while the ordinarily that transaction should have raised a resulting trust in favor of the husband, it now raises a presumption of advancement in these special relationships that we have identified. They emanated, like I said, from the historical foundations of marriage and family, where you have coverture and wives were under this coverture of their husbands, and the husband must provide for them, and all sorts of other dependency obligations. These presumptions, resulting trust and advancement, are reportable. Now, the presumption of advancement was used in the case of Idrisu and Obafemi, for instance, where the title was vested in the name of the wife. And she actually argued that she paid the purchase price of the property. And the husband argued that he was one that bought the property and that he conveyed it in the name of the wife because he was trying to evade scrutiny by government, by the federal government that he was working for. And trial court dismissed the claims of the husband on the grounds that where a presumption of advancement exists, the presumption of resulting trust would fail. In other words, there is a presumption that he intended to advance his wife, to gift his wife by buying property in her name. The court also rejected the husband's argument because, on the fact, there was nothing in the evidence to raise a presumption of resulting trust. Like we said, there are reportable presumptions. If there was clear evidence that this was not a gift to the wife, it was not an advancement to the wife, the court would have displaced that presumption of advancement. And so, based on these reasons, the court said that the argument of the husband would not stand. The case of Madu and Madu, the court of appeal held that where property is purchased by the husband in the wife's name, the wife holds its own resulting trust. And that even if there is possibility of the continuation of presumption of advancement, it was inapplicable to customary marriage. And I think that that customary marriage aspect is the main reason why the court actually denied it, because there is no clear evidence that that presumption has been abolished. There have been agitations for its abolition. Even in English law, there have been attempts to abolish the presumption because it is premised on this dependent and inferior nature status of wives and women also in English law and English society. And with the era that we are living in on human rights, equality, no discrimination, and what have you, there have been a lot of arguments that try to say that it should be discontinued and repealed. And efforts have been made in many jurisdictions to do that. The case of Stark and Dowding and the House of Lords held that the resulting trust does not apply to matrimonial or quasi matrimonial disputes when you have matrimonial disputes, and that constructive trust is better suited to such disputes because the resulting trust demands direct financial contribution. When you are having a dispute between the husband and the wife, it is usually difficult to establish these contributions that are regarded as direct because most of the times there is no evidence and there are no witnesses to the transactions between the husband and the wife. And Baroness Hale in Stark and Dowding noted that the presumption of resulting trust is not a rule of law and should move with the times. And the law should no longer presume that couples intend their beneficial interest to be coterminous with their financial contributions. Where a couple contributes to the acquisition of property, the law should not presume a resulting trust between a husband and wife, coterminous with their contribution to the matrimonial. Rather, while the title does not reflect their financial contributions, it should be presumed that the title that they intended is what is reflected on the deed. What the Baroness Hale was saying was that the resulting trust tries to say, what it does is that it tries to look at the financier of the property and say that, look, whoever is the financier is actually the legal owner. And so if there are two financiers, you presume that the property is held in trust for the benefit of both of them, assuming that the husband and wife both contributed money for the purchase of Black Acre, but the property is conveyed in the name of the husband alone. The resulting trust will say that the husband is holding his wife's portion on trust based on the fact that she contributed. But Baroness Hale was saying that these presumptions should not really stand because it's not a substantive rule of law, and that where you have the title in the name of the husband alone, for instance, then the law should leave the title as it is because that is probably what the parties intended to be their status regarding that property. Now, this argument could be beneficial and detrimental depending on the facts of the case before you. If, for instance, in Nigeria, let's take a case in Nigeria where the title is in the name of the husband and the wife has contributed money to that property. But of course, she has no receipts, she has no documentary evidence, she has no witnesses. She just gave the husband maybe out of 50 million, she gave him 30 million cash. Or in a way that cannot be, there is no physical, there's no documentary or eyewitness account or any other evidence. What would happen with the approach of Baroness Ale is that since the husband is the one that the title was conveyed in his name, then the title resides in him. Now, that would not be beneficial to that kind of a wife. But you will have that same statement being beneficial in a situation where the husband paid for the purchase price, but the property is conveyed in the name of both the husband and the wife. And the husband now comes to court and tries to say, no, my wife did not contribute. It was only me. I just put her name there because she's my wife. And now that we are separating, we are divorcing, I do not want to share this property with her. In that kind of a case, the approach of a Baroness Ale, that the title should stay where it is reflected on the title deed, will be beneficial to the wife. It will be beneficial to the wife. The burden of proof rests on the person who claims that the title is not according to the title deed. Okay? So the presumption could work injustice in some cases and may be beneficial in other cases. The resulting trust, therefore, as a means of settling property disputes, favors the use of direct financial contribution to the initial purchase price of the property. If a property is purchased by mortgage, the initial monthly payment, the resulting trust demands that the person that is claiming beneficial interest was part of the people who paid for that mortgage. It's not sufficient to say after the initial mortgage price has been paid, then the installmental payments years later I started contributing to it. For title starts at the point of the mortgage, or the price at the time the mortgage price was made. But the purchase price was paid, or the initial mortgage deposit was made, and future contributions would not be recognized in a resulting trust scenario. And then the resulting trust does not also recognize non-financial contributions to come to court and say, oh, we've been married for 25 years. In 25 years, I've taken care of the children, I've cleaned the house, I've assisted him in his career, I've done A or B. But you've never paid money directly to that particular property in question, the property in question. That will not be able to benefit from a resulting trust, and that spouse might lose out. The resulting trust, therefore, would not be of tremendous help in Nigeria, because in a typical marriage setting, what the trust demands will not be easy to establish in courts. The courts demand strict proof according to the rules of evidence, and anything short of that will not be tolerated. So we have spouses being unable to establish how their benefit, how their interests should be construed under the law. Then you have the constructive trust. The constructive trust, like any other trust, places title to property in A, and the beneficiary gets the equitable title, so that the trustee cannot utilize trust property against the interest of the beneficiary. It demands that there are two things. There is a common intention and detrimental reliance. When we say common intention, what is it saying? In a constructive trust scenario, it is demanded that there must be an intention of joint interest that is between the parties. The parties must have expressed, whether in writing or orally, or you can infer from their conduct, that intended that there is a joint interest in the property dispute, where the husband and wife say, oh, this property is mine, H says it's mine, W says it's mine. Or say it's a joint property. One of them comes and says, no, the title may be in the name of my husband, but it is actually a joint property. Constructive trust is saying there must be common intention that exists between the parties, that property should be joint property. And that common intention must be expressed. You don't just say, because I'm a wife and I live, and I did my wifely duties. I did this laundry, I did the cooking, I did the homework with the children, I used my salary to be buying food for the house. I was just doing all those things, while my husband was using his own money to buy land, to buy assets, to buy shares. I assumed that because we are married and we have a common identity, we have a family, we are in love, so that whatever belongs to my husband belongs to me, whatever belongs to me belongs to my husband. That was what I assumed. That was what I thought while I was married. The constructive trust, we don't accept that. It demands that you must share that intention. You must communicate that intention with each other, that both of you are joint owners. Not that you have that in mind, which you are, but you never expressed it. You thought that, well, since we are married, then whatever my wife has or my husband has belongs to me. And I assume that whatever is to me belongs to me. He says, no, the constructive trust says you must express it, you must communicate it with each other. Not that you have it in your own mind and assume that the other person thinks the same. So you have the case of Gissing and Gissing as an example, where the husband had paid for the matrimonial home, and it was vested in his name only. He paid for the mortgage, he paid for the installments, and he was paying it regularly till the marriage, till he started the marriage. And the wife, paid for furniture, did some things during the marriage, and but she never made a direct contribution or indirect contribution to the house. She never paid for the mortgage or the installments. And when the husband tried to sell the property, since it was in his sole ownership, the wife resisted the sale, claiming that she had a beneficial interest in the property. And the House of Laws held that he was not entitled to any beneficial interest in the house. That for you to have a resulting trust must prove that there was some money, some expenditures that you made directly to the acquisition of the property or to its development, whether they are buying the land or developing the building, and if you are not able to prove that direct expenditure, the person will not be able to claim any beneficial interest. Okay. And the court, the House of Lords said, contributing to the family needs, buying the provisions, buying clothes for the children, doing all those basic things will not fetch you an interest in the property of the other spouse. Now, then the second aspect of the constructive trust is that there must be a detrimental reliance. You must have relied on that assurance, that expressed common intention, not that you had the intention that the property belongs to both of you, but you must have relied on that agreement to your detriment. So we are buying the land, and the land is going to belong to both of us. So you begin to make payments, maybe to the account for this development of the property. And most of the time, the reliance is put by making direct or indirect financial contributions to the development of the property or the marriage. And that is really, really very critical. So if you have not relied on it, you've not done anything, and there's no evidence of any financial contribution on your part, the courts are likely to hold that you do not rely on this assurance, this agreement, this understanding. And so just doing domestic chores, has not been regarded as detrimental reliance. And in Lloyd's Bank and Rules, Law Bridge noted that to be detrimental, there must be some real weight and significance to what the claiming spouse has done. There must be something of weight and of significance, and that a wife who decorates the home, maybe paints the home and does some things around the house, will not enjoy beneficial interest because of such chores. The non-financial contributions, therefore, are not generally recognized as constituting detrimental reliance. But you have some cases which tended to hold that where it is substantial and weighty, then the courts the courts will be disposed to hold that there is a beneficial interest in the property. You have H against M property beneficial interest, where the unpaid work of a party in the other's business was regarded as detrimental reliance. She was working in the office of the person, and the court said that her contribution was that of a mother. She was like his mother to the children, helper, and unpaid assistant. And that if he had to pay for these kinds of roles, the husband would have had to pay a lot of money. So the implication was that she was entitled to some interest. You have Paul St. Jones, where also the lady refurbished the property, and the court said that by refurbishment of the property, She was doing something that either Mr. Jones would have had to do himself by paying money for it, if or by doing it physically himself. And either way, he would have to be charged for it. And because of that, she had done it. She was entitled to an interest. You have Hibs and Hibs too. Where the court said that they were cohabitants, and the court said that what the ex-cohabitant did was something out of the ordinary. It was not just something that anybody would do. And Brigham J said, I find it difficult to suppose that she would have been wielding the 14-limb sledgehammers, breaking up the large area of concrete, except in performance of some express or implied agreement. That's what she did. The only way she would have been doing all the works that she did on that property would only have been because there was an agreement between the parties that she would have an interest. It was not just what a cohabitant would be doing for the next. Yeah, you have LeFou and LeFou also. And these decisions, which tended to favor these kinds of contributions that are not financial, that are indirect contributions, they tend to reflect, the need to do justice and equity in this age, as and to understand the dynamics of marital life, that in most cases you would actually not be able to say that you put some money down, but you would have put so much effort into the particular enterprise that it could only be fair to give that person a beneficial interest. And that was why in Stark and Snowden, Lord Walker noted that what what the present position of the Lord excuse me, should be now is that we must recognize that the law has moved in another direction from the case of Rosette that we talked about earlier. And Lord Hope mentioned about that when you have put your resources together as a family, you are husband and wife, when they have put resources together, one person is doing the properties, another person is paying for school fees, one person is doing, you know, buying the cars, the other one is paying for the food, that it's a pooling of resources together. And when you have done all that, it will not be fair to say the person who has paid for the food should not have an interest in the property purchased by the one who has been buying assets. Because if that person did not pay for the food, the person that is buying the assets would be unable to have enough money to purchase the assets. So it's almost like saying that, yeah, is a loan in between them. Constructive trust has not been helpful because of these expressed, these conditions we talked about, that you have to establish. And because of the way marriages work, you will find it difficult in most cases for spouses claiming a beneficial ownership, and claiming that there is a difference between the legal ownership and what was actually in place as an existing amongst them as a couple. It's usually difficult for them to establish these elements of the constructive trust or the resulting trust that we have discussed above. The courts have remained very strict, demanding either you prove strictly under the property law regime that title resides in you, or if you are going to use a trust, be able to prove the components of a resulting trust or a constructive trust, so to say. Then you have the remedial trust, which is like a general doctrine of equity aimed at doing justice, that we should look at what is just or equitable between the parties. And in Hazel and Hazel, Lord Denning, in his typical equitable disposition, what raised that argument. I was ready to recognize that a wife should have an interest, should have beneficial interest in property which the husband had purchased, where engagements in the marriage relieves the husband of the expenditure which he ordinarily ought to have paid for. For instance, if she pays for the feeding of the family, because of that, she would be entitled to whatever the husband was doing with his money, which made him unable to pay for the expenditure of feeding the family. She would be entitled to that. So if she's entitled to that, if she's able to establish that, then it will be difficult for the husband to argue that she has no interest in the property that has been purchased. It will be difficult for the husband to argue. So Lord Dennis said that the law must be ready to recognize the right, while the wife with contributions which relieve the husband of expenditure, which he would have had to bear. By so doing, the wife helps him with his mortgage installments because he has more money in his pocket. If she's demanding for feeding of the home, she's demanding for payment of electricity bill, she's demanding for fueling of the car, he would not have had enough money to buy the property or properties or to pay the installments that are in. So that's what the general remedial trust concept is about. It moves beyond the resulting trust and the issue of direct financial contribution, constructive trust, to say, look, let's have this general doctrine of remedial. You remedy some injustice that has taken place in the marriage relationship. Also, you have what we call proprietary estoppel, which requires that where you have made some assurance or promise or expectations on one party and the other party has lied to its detriment. She has thought, for instance, being married to you, that whatever you are doing, she will have some beneficial claims because he's your wife or he's your husband, because of the way marriage works, because of the pulling of resources together, because of, so where there is that assurance and the person has relied on it to their detriment, that you can use proprietary estoppel. It demands that there is an assurance, promise, or representation based on one party, encouraging the other to believe that he or she owns or will be given some proprietary interest. So it goes beyond just an understanding, an assumption. There must be some communication or representation that you have some proprietary interest in this asset or that asset, and the person has relied on it to their detriment. So it is premised on the fact that it is unconscionable for you to now avoid giving that person an interest in the property. It is inequitable, it is unjust to deprive, for instance, the wife of an interest in a property which she had been given an assurance or representation during the marriage that you are co-owners. And because of that, she has conducted her life in a way that is detrimental to her interest. Now, in Nigeria, while we have said that the law does not really does not favor indirect contributions or non-financial contributions as a basis of receiving beneficial interest in property, there have been some snippets of decisions which try to give some form of remedial trust or proprietary estoppel, not really well grounded, but there are snippets of encouraging pronouncements under some cases in Nigeria. In Okere and Akaluka, a 2014 case, the court recognized indirect contributions of wives to property, which would grant them an interest, a beneficial interest. But when we take up a beneficial interest, I've emphasized the fact that this is like an interest, an ownership rights. And the basis was that the court said it was the performance of their functions as wives that enabled their husbands to perform theirs. And to deprive a wife and her children of a right in property that she made substantial contributions to its acquisition and development would be unconscionable. You see that word unconscionability again, unfairness and what have you. So it would be unconscionable to deprive that woman of those assets. And that because the way the marriage system works and wives are expected to support their husband, to support the home and the marriage, there's that tendency that they would not be able to acquire properties for themselves. There are even the way the culture of society is such that where she would have been able in some societies to be able to get evidence of her contributions, maybe you have a contract you sign. You don't have such transactions in Nigeria where the husband and wife sit down and have a contract, an agreement in writing as to what they are doing with their assets in the average marriage setting, not in all cases, but in the average setting. So those are the considerations that would weigh in the mind of the court and that inform this kind of position. You're going to hear and you're going to hear to it was said that it will be unconscionable to allow a spouse to claim exclusive possession of a matrimonial property, especially when the court can see that the conduct of the parties, whether it is expressed, they've said it, or it's inferred, determine their shared intentions. So in conclusion, therefore, the trust has not been really helpful in the context of marital property disputes. The limitations of those trusts are being examined. The resulting trust limitation, which requires direct financial contribution to the initial purchase price of the property in dispute. The problems of the constructive trust, because it demands that there is a shared common intention that is shared among the communicated with each other, and there is detrimental reliance. Most of the times, you will not find that common intention that is shared, communicated between each other. So these are some of the challenges in the trust concept. Direct financial contribution is a difficult thing to prove in a lot of marriages, especially in Nigeria. The spouses that claim beneficial ownership are usually constrained by evidential challenges inherent in the marital relationships. In the way the marriage works, society construes marriage, and how marriage couples comport their their relationship and marriage. It's not with an eye to litigation. Marriage is not, comported with an eye to dispute or litigation. And when litigation eventually arises, parties are put at a disadvantage as to their legal rights. The remedial trust gives discretion to courts to do what is just and reasonable in circumstances of the case, and it may prove useful in the future in assisting couples, who are trying to claim a beneficial interest in property. Then we looked at the proprietary estoppel, which we said also gives some measure of prospects for property rights in marriage. These are some of the considerations that are pertinent in marital disputes and in trying to use the trust concept to settle marital property disputes. Would said that these disputes are in a class of their own because of the way the marital relationship is happens. And when it breaks down, it's always a problem for the parties to establish their interest in disputed properties. And what it means, therefore, that in moving forward, it is incumbent, especially in the age that we are living in, that parties express their intentions. We're no longer in the age where you just keep quiet and assume that you have an interest in property, where you just give money. So in this age now, you have banking transactions, transfers are made. You, for instance, tell and you state the reasons, why the transaction is being made. So it may be easier these days to bring those evidence there, to bring out the evidence of direct financial contribution to particular properties. But there will always be that problem for spouses, especially wives, who did not make direct financial contribution to that particular property, but who have conducted their marriage in such a way that they are supporting their husbands with domestic chores, with financial contributions to the marriage, but not to the particular property in dispute, by paying for some other things in the home while the husband pays for capital assets, which now become contentious at the time that their marriage comes to an end. So what it tells you is that problem still remains because of our cultural setting, our religious setting, and social setting, which does not make marriage to be a transaction that is conducted with an eye to litigation. So at the end of it all, therefore, we can conclude that the trust concept, while may seem promising, has not really been helpful for spouses in Nigeria and in a lot of jurisdictions because of the challenges that we have identified. I'll see you at the next presentation. Don't forget to subscribe, to share, and to like the video. Thank you.